I'm not a lawyer, but if you want the recap of the arguments that took place in front of the Supreme Court today regarding former President Donald J. Trump's presidential immunity, I'm gonna break it down for you. Okay, so as you know, or should know, the former president of the United States, Donald J. Trump, is currently facing criminal charges in relation to his attempt to interfere and overthrow the 2020 election. I have a whole Trump playlist that breaks down all of his indictments, and I highly recommend watching those if you need like a full proper recap. Okay, so in response to these criminal charges that Donald Trump is facing, Trump's attorneys are arguing that the actions Trump committed in relation to the 2020 election were official acts done in his capacity as president and are therefore protected from criminal prosecution. And Trump's attorney roots that line of thinking in Article 2 of the Constitution, which, according to his interpretation, says that courts cannot sit in judgment over a president's action. Now, historically, this has only applied to civil liability, meaning that you, watching, couldn't go sue the president for his actions as president, but Trump's attorney is saying that this line of thinking also applies to criminal prosecution as well.
For 234 years of American history, no president was ever prosecuted for his official acts. If a president can be charged, put on trial, and imprisoned for his most controversial decisions as soon as he leaves office, that looming threat will distort the president's decision-making precisely when bold and fearless action is most needed. Could President George W. Bush have been sent to prison for obstructing an official proceeding or allegedly lying to Congress to induce war in Iraq? Could President Obama be charged with murder for killing U.S. citizens abroad by drone strike? The answer to all these questions is no.
The government, on the other hand, are arguing that the action President Trump did were not official acts that were done in his capacity as president and were instead private acts and therefore make him not immune from criminal prosecution. And the clips I'm going to play really come down to three things. Number one, how are official acts done by a president actually defined? Like, what is considered an official act versus what is not considered an official act? Number two, do the acts that Donald Trump actually committed fall into the category of an official act or a private or personal act? And then the third thing is, those acts are indeed official. Does the law actually support that official acts are protected and prevent the president from being criminally prosecuted? The first clips are the Supreme Court and Trump's attorney, John Sawyer.
If the president decides that his rival is a corrupt person and he orders the military or orders someone to assassinate him, is that within his official acts for which he can get immunity?
It would depend on the hypothetical, but we can see that could well be an official act.
It could, and why? Because he's doing it for personal reasons. He's not doing it like President Obama is alleged to have done it, to protect the country from a terrorist. He's doing it for personal gain. And isn't that the nature of the allegations here? That he's not doing these acts in furtherance of an official responsibility. He's doing it for personal gain.
I agree with that characterization of the indictment, and that confirms immunity, because the characterization is that there's a series of official acts that were done for an unlawful.
No, because immunity says even if you did it for personal gain, we won't hold you responsible. This is what you're asking us to say, which is that a president is entitled not to make a mistake, but more than that. A president is entitled for total personal gain to use the trappings of his office. That's what you're trying to get us to hold, without facing criminal liability.
So I think I now understand better your position. You are saying that for the private acts of a president, there's no immunity, but for the official acts of the president, there is immunity. Why is it, as a matter of theory, and I'm hoping you can sort of zoom way out here, that the president would not be required to follow the law when he is performing his official acts? Everyone else, there are lots of folks who have very high-powered jobs, who make a lot of consequential decisions, and they do so against the backdrop of potential criminal prosecution if they should break the law in that capacity. And we understand and we know, as a matter of fact, that the President of the United States has the best lawyers in the world when he's making a decision, he can consult with pretty much anybody as to whether or not this thing is criminal or not. So why would we have a situation in which we would say that the president should be making official acts without any responsibility for following the law?
I respectfully disagree with that characterization. The president absolutely does have responsibility. He absolutely is required to follow the law in all of his official acts, but the remedy for that is the question. Could he be subject to personal vulnerability, sent to prison for making a bad decision after he leaves office?
But other people who have consequential jobs and who are required to follow the law make those determinations against the backdrop of that same kind of risk. So what is it about the president? I mean, I've heard you say it's because the president has to be able to act boldly, make kind of consequential decisions. I mean, sure, but again, there are lots of people who have to make life and death kinds of decisions, and yet they still have to follow the law, and if they don't, they could be sent to prison, et cetera, et cetera. So wouldn't there be a significant risk that future presidents would be emboldened to commit crimes with abandon while they're in office? It's right now the fact that we're having this debate because OLC has said that presidents might be prosecuted. Presidents from the beginning of time have understood that that's a possibility. That might be what has kept this office from turning into the kind of crime center that I'm envisioning. But once we say, no criminal liability, Mr. President, you can do whatever you want, I'm worried that we would have a worse problem than the problem of the president feeling constrained to follow the law while he's in office.
I respectfully disagree with that because the regime you've described is the regime we've operated under for 234 years. There has not been an expectation based on 234 years of unbroken political.
All right, let me.
And then these are the clips of the Supreme Court and Michael Dreeben, who represents the Department of Justice.
Mr. Dreeben, does the president have immunity, or are you saying that there's no immunity, presidential immunity, even for official acts?
Yes, Justice Thomas, but I think that it's important to put in perspective the position that we are offering the court today. The president, as the head of the Article 2 branch, can assert as applied Article 2 objections to criminal laws that interfere with an exclusive power possessed by the president or that prevent the president from accomplishing his constitutionally assigned functions.
Mr. Dreeben, you dispute the proposition that a former president has some form of immunity. But as I understand your argument, you do recognize that a former president has a form of special protection, namely that statutes that are applicable to everybody must be interpreted differently under some circumstances when they are applied to a former president. Isn't that true?
It is true because, Justice Alito, of the general principle that courts construe statutes to avoid serious constitutional questions, and that has been the longstanding practice of the Office of Legal Counsel.
Do you agree that there are some aspects of Article 2 presidential power that are exclusive and that Congress cannot regulate and therefore cannot criminalize?
Absolutely. Okay. Our view is that there is a balanced protection that better serves the interest of the Constitution, that incorporates both accountability and protection for the president. And I want to go through the protections that do exist.
You really, did I understand you to say, well, you know, if he makes a mistake, he makes a mistake. He's subject to the criminal laws just like anybody else? You don't think he's in a special, a peculiarly precarious position?
He's in a special position for a number of reasons. One is that he has access to legal advice about everything that he does. He's under a constitutional obligation he's supposed to be faithful to the laws of the United States and the Constitution of the United States. And making a mistake is not what lands you in a criminal prosecution.
So that's essentially what the arguments were about. And now they are going to have to vote and figure out, is former President Trump actually immune from criminal prosecution or not? And based off of this decision, Donald Trump could have to fight these criminal charges or not.